Hi, everybody, and welcome to Raw Law. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome, everyone. This is the show where we answer your questions and we talk about your comments, and we're live from my office in beautiful Bensonhurst, New York. So let's see if we have any questions. I did a few consults already today. I did about 2 consults today and 2 or 3 yesterday. I still have a few more left to do. I'm going to see perhaps I could get one more in later today. So it's always better to do like a full consult with me. And some of the ones that I did, one of them yesterday actually lasted more than an hour, and the other one was about 30 minutes. And today we did one for about 30 minutes. So, it's always better because we could do a deeper dive into your case. We could really find out more information. But this could also be helpful if anyone joins and asks us a question. We just answer your questions live, and we could talk about certain issues, certain topics that are more common, and that answer not only the questioner's question, right? The person who makes the comment, but also it could apply to other people, so it could be helpful. So let's see if we get any questions, and maybe in the meantime, while we wait for people to join and to ask questions, what I could do is I could jump into another screen here. I'll open up our channel, and I'll see if there have been any questions on the channel, because sometimes we get really good questions on the channel, and maybe I could use some of those questions as to answer some of those. So let's see what we have there. So if we go to our channel and we go to the community tab, see what kind of questions we have. Here's an interesting question just a day ago from Doretta Dotson, and she asks, so how much should the policy be if someone hit you in a U-Haul truck? And she's responding to the video, how much insurance after a semi-truck wreck? So the way it works with, semi-trucks is that usually they're going to have at least $750,000 in insurance. It could be more. If it's a bigger company like JB Hunt, for example, they could have $1 million primary with like $5 million excess, and there could be layers and layers, beyond that. But usually there's going to be at least 750. That's for a tractor and a trailer. But I think what she's asking is if somebody hits you in a U-Haul truck. Now, U-Haul is something that you rent, so it could vary depending on the state you're in. The best thing to do with that is to probably just obtain it in your specific case. So depending on the type of U-Haul truck, where you, whoever hit you, you should find that out, and they'll just tell you. So I don't think there's going to be the same insurance for every U-Haul out there. It might be different, right? Depending on the type of truck, depending on the state, it gets a little more in depth. So there's not going to be like one universal answer, but it's not too complicated. Like you just ask them and they have to tell you the full insurance, meaning primary and umbrella or excess. And also in a lot of places, it's automatic, meaning that you don't even have to ask. Like in New York, when you show up at the preliminary conference, which is the first meeting with the judge, you get that information right away. And it's just part of the preliminary conference order. It's already like pre-printed in there that the defendants have to tell you the insurance. And if they don't, then you can, send a letter, ask the judge, make a motion, but you'll get it easily. So, yeah. And here's a question from Stephen Barrett. He asks, how close are you to a settlement after both sides have been deposed? I think he means deposition, deposed. Defendant took full responsibility. It's an ACDF truck accident, $6 million in coverage. And his lawyer said his deposition went great. So, that's kind of a general question. It's kind of hard to answer because, of course, when both sides have been deposed, discovery in that sense in the questioning has been done. So now you have the transcripts, or if it was videotaped, you have the video. So that's all been done. So, at this point, you can certify it as trial ready. And at that point, you can try a settlement conference and mediation. So you're getting closer. It could settle right now. There's not really any specific place where it could settle, or it could never settle, right? Because if you're looking, let's say, for 6 million and they want to pay you only 25,000, well, then you're going to have to go to trial, right? And have the jury decide. So it's always different. There's not really any specific time. You're going in the right direction. Obviously, you're like, if you ask me how much of the case is done, I would say, well, at least 50% is done, right? Maybe more than 50%, because after depositions are done, as long as there isn't any other paper discovery like IMEs or exchange of documents, you could certify it as trial ready. And then depending on your state, you either get a trial date, or in New York, you don't get a trial date. You just certify it as trial ready by filing what's known as a note of issue. And then you just wait on the trial calendar, depending on your county. Usually you're waiting about, I would say, at least a year, could be more. Like in the Bronx, it might even be 3 years, right? In Brooklyn, it might be like a year and 5 months. And then you get your trial date. But while you're waiting, that's when 90% of cases settle, either when you're already at the 11th hour, when you are picking your jury, right? Or it could be earlier. It could be like around this time where depositions are done, you're about to certify as trial ready. So it could be that point. And then Jorge asks, hey, Mr. Arkady, I'm deep in the litigation process. My deposition and IME is done. Defendant's deposition is done as well. I've had a lumbar laminectomy knee surgery. I'm having a second knee surgery in 2 weeks. Do I have to go through another IME exam and deposition? So you don't have to, but if the defendants request it, then, probably the judge will give it to them, because if you had one knee surgery and they got to question you about your treatment, what doctors you went to, what the doctors did for you, about your limitations, what you couldn't do after that first knee surgery, and now you need a second knee surgery, and you're claiming the second knee surgery is also as a result of this accident that you're suing for, right? Well, now they might want the opportunity to just question you about the second knee surgery. To what extent did your activities become even more limited as a result of the second knee surgery? Like, what role did the second knee surgery play in making your day-to-day life worse? What doctors did you go to? Who said you needed a second knee surgery? What was the surgery to your understanding? All these kinds of questions. It might be a very quick deposition. It might only be like an hour, because your lawyer should not allow them to re-ask the same questions they asked at the full deposition about liability and the first knee surgery, but they are entitled to one if they request it. Now, I think most defense lawyers will request it, because remember, the way defense lawyers make money is they bill the insurance company and they get paid hourly, right? So if they take a deposition of 2 hours and they say, well, I want $350 an hour, they're going to make $700 for that deposition. So it's unlikely they're going to waive it. But sometimes if it's like in-house counsel for an insurance company where they're not billing the insurance company and they don't really need it, they could, in some rare circumstances, perhaps waive it. But most likely you will need to do a deposition. Now, with respect to the IME, it really depends on their strategy. I think they probably would want a doctor to examine you after the second knee surgery to talk about the fact that, probably is going to be the same doctor that examined you after the first knee surgery, but now they're just going to double down on their theory, whether it's that your injury is pre-existing, it's not from this crash, or, whatever their report said as a result of the first IME, they're probably going to either double down on that or maybe slightly change their theory because you've now had a second knee surgery, but most likely they're also going to want that. So yeah, most likely they are going to have that, both IME and deposition. And then Angela Davis says, I was first communicating with the claim adjuster. I'm a truck driver. I was hit by another truck driver. I was honest and upfront with her about my prior surgical fusion that happened in 2017. Until one weekend, I get an email from their attorney. She did give me the declaration page I asked for, reserve. There was not one place yet. I have an experienced truck trial attorney. My case is in new, but I do my journals. I do all my doctor's appointments. I have an EMG test scheduled soon. But my question is, how can I find out any umbrella coverage that the trucking company might have? Okay, so if you have a trial attorney, just have them do it for you. Just have them send a letter to the defendant trucking company as part of the lawsuit. They're going to probably file a lawsuit. And then, if there's no lawsuit, it depends on the state. Like in New York, we could ask for the policy limits even pre-litigation. It's like 3520F. It's in the insurance law, and they have to tell us. But, other states, they might not have to give you the deck sheet or not have to tell you the insurance. Like I think in New Jersey, they don't have to. So sometimes they'll tell you anyway. You could kind of ask when you're on the phone with the adjuster. You could say, is this a minimum 25 policy? And they might say, no, it's 100. Or they might say, no, you know what? It's not 25, but I can't tell you the limits because we don't have to disclose and I'm not allowed. I could lose my job, right? So it's just kind of their corporate policy. If they don't have to by law, they're not going to tell you. So yeah, so in that sense, you just file the lawsuit. And once the lawsuit is filed, you just get it automatically as part of the discovery. And if they don't give it to you, I've never really had any situations where they would not give it to me. Like one case, actually, I was talking about it yesterday in the consult, where I took over a case from another lawyer, and the lawyer wanted to settle the case for like 600,000, and there was only $1 million in coverage. And I asked, well, is there umbrella? Is there excess beyond the $1 million? And the lawyer who represented the plaintiff before me calls back and he's like, well, I don't know. And I don't even care. I'm like, really? You don't even care? And then I find out, wait a minute, there is excess and it's a 25 million and it's with Chubb. And the primary was with a different company. I forget the name, some smaller company for 1 million. So you got one, but you got 25 more. And, the injuries didn't warrant the full 25, but I was able to get the full one. And I think I got 250,000 more from the excess. So I got 1.25 million. So much better than the 500 that he wanted to settle it for. He didn't even have the 500. That's what he wanted, right? That was his like demand or whatever you call it, whatever people call it. So anyway, but the point is that you could find it out. It's really easy and you don't even have to do anything. It's just automatic. You just, so you don't even have to ask for it. In New York, it's 3101F of the CPLR, the Civil Practice Law and Rules. They just have to tell you. And there's another section of the CPLR that also mandates it. I forget the number off the top of my head. It might be 4420 or something, but it doesn't matter. But two different sections, and it's right pre-printed in the court order. So when you show up to court, it's already pre-printed. The defendants will tell you their primary policy and their excess policy. Now, most states are going to be the same, whether it's pre-printed or not, whether it's automatic, doesn't really matter. You just ask and they tell you. There's not really any case where, they could get away with not telling you. It's just very simple. So, yeah. And then Khalif Cool says, hi, Arkady. My doctor told me not to do anything to re-aggravate the nerve in my back. And my PT doctor told me not to do any sit-ups. Okay, yeah. I mean, I would listen to them, of course, doctor's advice, medical, your health. That's very critical. So I would listen to the doctors. And then I'm a Beam says, hi, Arkady. In Nassau County, how long after the note of issue do you get a court date? How much does it cost to hire the best care planner? Oh, like a life care planner, like an expert? I mean, it really depends. Probably it'll cost at least, 4,000 to 5,000, maybe a little more, a little less than that, in that range. How long does it take to get a court date? I would say about a year. It could be a little more, but not too much more. Nassau County is actually pretty efficient and fast. So in that sense, it's good. It is conservative. And in that sense, it's not as good as, let's say, the Bronx, right, where you would get more money for your injuries. But so it's good in the sense that it's a smaller county where the case will move faster. You won't be waiting on the trial calendar for like 4 years like you could in the Bronx, but the amounts are going to be smaller. Like in the Bronx, you might settle a case for 5 million or, whatever, get a verdict of like 5+ million. Whereas in Nassau County, that same case might go for like 1 million or maybe even less than that. Right. So it's considered a more conservative county. And then Miss B says, hi, Mr. Arkady, could you please do a verdict search on CRPS cases in the Dallas, Texas area or Texas in general? Yes. Oh, yeah. I think you had asked that before. Yeah, I'm going to do that. I'm going to definitely get to that and get that done. And then Steven says, okay, how much? ACDF with significant loss of enjoyment of life, home, work, and hobbies, 6 million coverage, 300 in medicals, have the best lawyer for court. Driver took full responsibility. And this is in Los Angeles. Yeah, well, I mean, I can't really tell you like how much based on a YouTube comment. If you want to discuss like my ideas about value or have me do maybe like a verdict search of similar cases, the best thing to do is to text me. That's 347-566-9595. We could chat. I could give you some ideas. But look, if you have ACDF and there's only 6 million in coverage and you have all these injuries, I think there's a chance you could get the full 6, right? Or something close like 5 or 4.5. But I usually ACDFs in Los Angeles, you have to add in all the different categories of damages. So obviously there's going to be, the biggest is going to be your pain and suffering, your loss of enjoyment of life, both past from the date of the incident up until the trial, and future from the date of the trial for the rest of your life. I don't know your age, but let's say people are living to be like 83, 84. So, whatever that is, from your current age to 83, that could be like 50 more years, right? 40 more years. So, and then of course your lost salary, depending on how much you were making, with increases and overtime. So you get an economist to calculate that. And then of course also your medical bills, right? Your future medical expenses. So you get your doctors to calculate that with economists or life care planners. And then just that, like I had a client who was 57 and he had a 1-level fusion, and his future medicals were like 2.8 million. So, that's just an example. But like if you have I don't know if you have 1 level or multiple levels, but if just your future medicals are close to 3 million, right, with an ACDF, then imagine everything else, right? So remember, this isn't like one or the other. This is that you're entitled to all of this. So you have to just plead your case properly. Like you have your pain and suffering past, pain and suffering future, loss of enjoyment of life, loss of convenience, right? All of the things that you're entitled to under the pattern jury instructions in California, future medical costs. Also, the economist can extrapolate what the doctor says will be needed, like MRIs, futures. Remember, if you had ACDF, well, there's adjacent segment disease, so you might need a surgery at the level below, the level above. Well, each surgery could be close to 100,000. And what about MRIs and prescriptions and physical therapy and pain management, like epidurals or percutaneous discectomies, follow-ups? It all adds up over the course of a lifetime. Medical care is expensive. And then, of course, your salary, depending on how much you are making, with increases, wage increases, and overtime. And so it really could be the full 6 easily if it's done the right way. And then Lisa says, father's trial, fighting for what damages the county should owe, 17 surgeries. I'm not sure what the question is, though. Okay, and Angela says, I'm in Georgia. My accident happened in April of this year. Yeah, I mean, the best thing to do would be to text me, 347-566-9595. We could hop on a call and I could help you out with that, answer your questions. I might be away for a few days, and we'll be away next week, but I could try to maybe schedule a few consults. But definitely when I'm back after Labor Day, I'll be able to do a few more consults and make myself available. And then Angela says the primary is 2 million. So that's good, 2 million. And then remember, you don't know if there's excess. So there could be 2 million plus there could be excess. I mean, one way to check is just like you said, I think you said you're a truck driver too, right? So one way to check is just like look under I think it's called SAFER, or the U.S. Federal Motor Carrier Safety Act. They have a website, and then sometimes they tell you the insurance right there, and you could see how many, the defendant, the person that hit you, how many trucks do they have. So it says like power units, they have like 40. Well, they're probably going to have millions in coverage, because otherwise they can lose their 40 units, right? They don't want, if they have 1 unit and that's all they have, then it could be smaller. But if they have 2 million already, there's a good chance they might have excess umbrella, because those trucks that only have like 1 unit, they might have only 750. I believe that's the minimum that they have to have if it's a tractor trailer. Let me see. This is the so yeah, it depends on the type of truck that hit you in the company. And then Veppy says, hello, Mr. Arkady. Hi. And Lisa says that she gathered all her records and found counts of fraud and is looking for an attorney in Missouri. Yeah, I'm happy to help. I just don't know. The best thing to do, let me know like the facts of what happened, and then the injury that you sustained, the date of the incident. We could do I think we might have done a call on this, but if not, then I could try to do a call with you and try to figure it out and help. But sometimes people call, right? And they say, oh, do you know about the eggshell plaintiff? I'm an eggshell plaintiff, or I believe that, this is like fraud but see, those are legal terms. I don't think you should be making legal declarations, right? It's like, I'm not a doctor, right? But I don't want to like self-diagnose. If I have a pain, I'm going to say, I have, this or X or Y condition, medical condition. I go to a doctor and let the doctor diagnose me. The doctor's going to ask me, well, when did it start? How are you feeling? And then let the doctor figure it out. So it's the same thing with law. Some people say, I am an eggshell plaintiff, or I believe I have a pre-existing condition. But it's don't jump the gun. Just let the lawyer know the facts. Like always start with the facts, like what happened, tell the story in a way where the lawyer, whether it's me or someone else, could see what is happening. Like they're watching it, they're eating popcorn, they're watching it on the screen, right? And then let the lawyer tell you what the issue is. That's always better. And then Miss B says, in your opinion, would an approved SSDI claim warrant a full policy payout if my disability is due to my medical issue from my MVA? I mean, I don't really know. I've never really seen that happen just because of that, right? So whether or not you get an approved Social Security disability claim, that's like separate from the case. It doesn't necessarily follow that if you get approved for Social Security disability, that they would tender the policy. They usually tender the policy just based on the severity of your injuries. But from your comment, if you have like a CRPS, well, that's a really severe injury. So it's likely you could get a policy tender depending on how much the policy is and, all the other facts and circumstances. But so basically, like I'm basically saying that just the fact that you're approved for SSDI doesn't mean that you're going to get a tender. But obviously, it's one of the pieces of the puzzle. Kind of, it helps you that the SSDI believed that you were disabled and gave you that finding. That doesn't hurt. That's one of the pieces of the puzzle. So it's a step in the right direction. And then Tindo says, hi, Arkady. I was cut off by a drunk driver in October 2024 in Michigan. I dislocated and broke my elbow in 5 places, went through ORIF in my elbow. How much is that worth? Okay. Yeah. I mean, if you had a dislocated elbow in 5 places with ORIF, I mean, that could be a big case. I mean, I've settled cases like that anywhere from, if it's one ORIF surgery, it could be anywhere from like 500,000 to $1 million plus, depending on how much this drunk driver has in insurance, right? You want to find that out, or I don't know, maybe you already know that. Some drivers might have 500, 1 million, or 1 million with 5 million excess. Others might only have 25K, right? So that's the real question, is how much insurance they have. And then with a case like that, I would try to take the full policy. And then Black Pearl says, Arkady is the best. Thank you. Angela says, I truly do enjoy your videos and the information you give. Trust me, it helps more than you know. Oh, thank you so much. I'm glad to hear that. And like I said, for like Angela or for anybody, if you need a consult, just text me. It's 347. Let me drop it in here. 347-566-9595. I'm happy to help. And then Amiri says, my attorney filed suit in July. Is it a good sign the trucking company is dodging the process server? That's weird. I don't know. I don't know if that's a good sign. I mean, usually the trucking company is dodging the process. I don't know. It's hard to say. I don't really have that issue, really. I mean, I don't really serve process like myself. I usually just give it to the process server. And I know usually things just get served. Sometimes I do hear of certain situations where the process server says, you know what, I can't serve. Like I remember one situation where we had this landlord and he was like not living there and his son was like managing a building, but it was like a small building and we're trying to serve him. And he's like not living there. He's living somewhere else, but the address that he's actually living in was like an empty lot. So we go there, it's like an empty lot. He's like, you can't be living here. And then we have to do this like deeper dive. And the process server was like, you got to do research, get a private investigator to find this guy. But I don't know how a trucking company would dodge service, because if it's a company, you could just serve the Secretary of State, right? Or you could just go there. How could they? Are they not open for business? Are they like? So I would have to know how they're dodging it. But it's not really good or bad. It's just weird, But I would definitely try to. Obviously, you need to serve them or have nail and mail or some kind of service according to your state's rules, and then you get the case started. But the trucking company is going to have to notify their insurance company, who's going to have to hire a defense lawyer, who's going to have to appear in the case. And that's what you want. That gets the ball rolling. Then you get depositions, preliminary conferences with the judge, depositions, exchange of documents, and moving towards trial. So you're on the right track. And then Lisa says, what about recalled medical devices? A greenfield filter vena cava. That I'm not sure. I don't really do those. I know some lawyers do cases of medical devices. I think that's more of like a mass tort, right? Like the medical devices or the defective drugs. Like I know at one point there was lawsuits about Vioxx or other drugs like Xarelto and some devices, I think knee implants that were dangerous, Depuy knee implants, recalls. So I don't really do those, but I've been involved in some of them, and to the extent that, if I have clients who need that, what I could do is I partner with a firm that specializes in that, and then they handle the litigation, and I could be involved, and we partner on that. And then Real Eyes says, how conservative are Iowa courts for personal injury from a fall where negligence is involved? So Iowa, yeah, I mean, they're, I don't really know specifically like how conservative the Iowa, it's not really about the Iowa courts, it's more of the jurors. So what you want to do is have an Iowa trial attorney that's very familiar with how to pick the right jury, that can appeal to Iowa jurors. And I've actually had a lot of cases in Iowa where I've worked with a local Iowa firm and they've done really well. Like just recently, another YouTube viewer contacted me and I gave them an Iowa lawyer, and I think they got the full policy tendered. And it was a pretty bad crash where it was I think $1 million or pretty big policy, and they got everything tendered. And I had a few other cases in Iowa. So it definitely can be won. And there's like a few lawyers that I know in Iowa that when they go to trial, they even get tremendous verdicts, like even complicated cases like medical malpractice, and they're getting like 30 million, 20 million, because they're just really good. So it's if you're in the right hands, right? If you have the right attorney that knows how to do it, it can be done. But Iowa probably is more conservative than, let's say, the Bronx, New York, right, or a place like that. So I think a lot of it really focuses on your mentality and your experience and your ability and the way you approach it. Because if you approach it from like this defense mindset where, you're trying to win the lawsuit lottery and you're just like, you're too greedy and things like that. And then if the plaintiff lawyer thinks that, or if the plaintiff lawyer maybe only has experience because they used to work in defense and they don't have trial experience, and they don't know how to pick a jury the right way, then you could be really, out of luck, like really in a bad way. It could be zero. But if you are in the right hands, you could get a really tremendous result. So. Okay, and then Steven says, thanks for the videos. They provide knowledge, support, and some expectations of what to expect. Thank you. Okay. Oh, that's good. I'm happy it's helpful. And Jennifer says, hi, Arkady. Can you please briefly explain what happens when a favorable plaintiff verdict is appealed by the defense and how long that process takes? Yeah, so if you get a good verdict, the defendant could appeal, and depending on where the appeal is pending, it could take another year or two. And then the appellate courts, like at least in New York, have been fairly conservative. So meaning if you get a nice verdict, like let's say, I don't know, 10 million, it might take you 2 years to write a brief. And it's basically like writing a whole book with the, plus you have the appendix, which is like the transcript of the trial. So the court reads everything. But then in the end, the court might say, you know what, that's too much. That's excessive. It's, it's not based on the credible evidence. So we can't sustain 10 million for these injuries. You have to take less, right? You have to take like 1 million. And if you don't, then do another trial. And it's not really a great position to be in because either you have to do the whole case over again, pay all your doctors again, right? Which could be like $100,000. Plus, you waited 2 years for this decision of the. I mean, we probably waited years to get to trial. You did the trial, you won, but now they're saying do it all over again because it was too high. So yeah, it's not really great, unfortunately, with appeals in New York. It's known as remittitor, but they're like you're basically remanding the case back or telling you to take a much smaller number. And Lisa's talking about fraudulent charges and that they are breaking laws. Yeah, but I'd have to know more. I don't know who they are. You know, they hacked a phone. Yeah, but yeah, again, like I don't really. It's hard for me to say because I'd have to know who they are. You know, who are they? You're just saying they, but I would have to really get more of the facts. Okay, and then Angela says you're telling the truth about when you think you have a pre-existing injury because that's what I thought too. But now I have a new injury. I jumped the gun also. I said pre-existing at first. Mm-hmm. I mean, pre-existing is fine. If you have pre-existing, it doesn't mean you can't recover. Pre-existing is basically like the condition you were in before you got into the crash or before you fell, right? Before you had the incident. So you are who you are, right? It's to the extent that you were made worse. You don't have to be in a pristine, Olympic perfect shape. You don't have to have a six-pack to recover. You know what I mean? So it doesn't really matter. What matters is, to the extent that you were made worse. Because if you had, let's say, I think I also, this is funny, I also had this come up at a consult, I think today. So say, for example, that you have an L5-S1 bulging disc. That's your injury. You already have it. You know you have it. You've had an MRI. And then all of a sudden, you get into a car crash. And then they do the MRI after the car crash, and they find an L5-S1 bulging disc. The same thing. Well, they're going to say, "Well, we're not gonna pay you for this. You already had it before," and they're right, because why should they pay you for what you already had before the crash? Meaning, if the crash had not even happened, and this MRI was taken, you had this L5-S1 bulging disc because an MRI was taken, let's say 6 months before, and it was found, right? And the two MRIs, they're identical, so they shouldn't pay you. And if you're trying to get money for that, it's almost like a fraud, right? It's not fair. Then you are like one of these lying, cheating, money hungry plaintiffs. So it is what it is kind of thing. But it's to the extent that it was made worse. So if you had this L5-S1 bulge before, but you were asymptomatic, you weren't going to do anything for it, you were completely fine, living your best life, going to the beach, swimming, working, whatever. And then, boom, you get hit by a truck, and now you have an L5-S1 bulge. But they're saying now it's not a bulge. Now it's a herniation. Now you need a fusion. Well, that's to the extent it was made worse. You get money for that. So pre-existing is not really a problem. It's just the way you frame it and the way you deal with it. So, yeah. So pre-existing, I don't think is really an issue. I mean, it could be an issue, but it usually, from what I've seen in most cases, is, you can show to the extent that it was made worse. Rafa says, "Hi, Arkady. Ralph from RVC. Hi, how are you?" Slip says, "Hi, I just wanted to say thank you trying to help me find a lawyer. I finally settled with new counsel, and they are fantastic so far." Oh, you're very welcome. I was glad that I was able to help. I was trying to do my best, to help. And then let me see. Jennifer says, "Thank you for the detailed response. Now my 8-year-old son wants me to ask you where you got your Arkady license plate." Oh, the Arkady. I think that's actually one of the YouTube viewers sent that to me. I forget who it was now. Oh, yeah, I think it was a YouTube viewer from like upstate New York. And she called in, and she had also needed a lawyer. I tried to help her find a lawyer. And I don't think it actually like even worked out, but she was so nice that I guess she makes these, and she made one for me, and she sent that in. So I was like really grateful for that. That was really nice. And then Ben says, why would the lawyer want to place a motion to consolidate my case if I'm suing New York City and the contractor? Have you heard of the 117 million verdict in New York? Does the client really get that much? So the reason they want to consolidate is because, if whatever reason there are two different cases, they want to consolidate them into one because it's not really efficient to have two different cases out there, right? Because then you have two different trials and it just doesn't really work. Sometimes the court consolidates by itself, even without a motion. The 117 million verdict, I don't know which one. And there have been a few different ones. I think I did a few videos about them. I know there was one for like 120 million or something like that for a brain injury case, but it got reduced to 20 by the appeals court, and 20 was like the highest that's ever been sustained in New York. The 117, oh, maybe you're talking about that one that the doctor got, he had a lot of lost wages, the doctor. I think I did a video about that, the 117. That might have been the doctor who was, I actually have the transcripts from that case, and I was reading up on it, and I've done a few CLEs and workshops with the trial lawyer who did that case. So I know him really well. We actually go to the same events, like when I go to the Trial by Human events. I think he also goes to some of those. So I haven't actually met him, but I've heard good things about him. He's a really good lawyer. But no, the client doesn't really get that much because, like I said, well, with the 120, what they do is they appealed it and it got knocked down to 20. So then they did get 20 in that case. So with the 117, I don't know what happened to it. I'm assuming it's somehow settled or it got knocked down. But like in New York, we have this remitter. So they just appeal and then, they reduce it drastically. So I'm not sure what the final amount was of the 117, but usually it's a lot less. Like 120 to 20 is you lose 100 million, right? That's a lot less. Now in California, other places you could actually keep it. Like in the case I did also videos about where it was 23 million for when the truck hit the car in the rear. I think it was the Miyamoto case. And the lady had a TBI and a fusion, and the lawyer got like 23 million, but it jumped up to 34 because of interests. And they did like a 998, which is like an offer of judgment and all these other things. It was 34, and there was not even an appeal. It just paid the 34. I was like, wow, I wish we had that in New York. Wow, I could retire. But unfortunately, or maybe I have to move to California, do some cases out there. And then Ben also says, if the defense files a motion for summary judgment and they lose, do I automatically collect 9% interest? No, not at all. No, why would you collect any interest? It's only if you file a motion for summary judgment and you win. Like, for example, if you're stopped at a red light and the defendant truck, let's say, hits you in the rear, and you file a motion and you say, well, there's not any issue for a jury to decide because I'm stopped at a red light. That's what I'm supposed to be doing. Sitting here like a careful driver stopped at a red light. It's red. I'm stopped. And this truck is speeding. I don't even hear any brakes. Slams me in the rear. It's his fault, right? There's not any issue where a jury could say, no, it's my fault. It's as a matter of law. So now you get summary judgment for the plaintiff. You have to file the motion and you have to win. And at that point, you get 9% interest against a private defendant. If they make a motion for summary judgment, what they're saying is there's no issue of fact by which a jury could decide that you, as the plaintiff, can win and that they should win. So if they win, the case gets dismissed. If they don't, meaning if the motion by the defendant for summary judgment is granted, you lose, the case is dismissed. Summary judgment is like a trial. You have to put in affidavits and evidence in admissible form. The judge reviews everything. And if he finds that they are correct and there is judgment as a matter of law, well, now you lose. The case is over. It gets dismissed. If the summary judgment by the defendants is denied, which is what you're saying, right? Defense files a motion and they lose, then the case just survives. You continue. You don't get anything. You just continue as if they never made a motion. But that's what you want, because the other option is it gets dismissed. You don't want that, right? The case is over. So those are the two options. Either it gets dismissed or the case survives and continues, but you don't get anything. And then Kevin says, can you make a video on a case you lost and what you could have done better in it if you could go back? Maybe. I don't know. I haven't really lost that many cases, but there is one case that I kind of lost. in a trial, but I was really young. I think it was like 1999, and it was like a small case. It was a really tough case because the lady fell in her own apartment, and she tripped on like a tile in her own kitchen, and she broke her leg. And she said she complained about the tile, but it was like her tile in her kitchen in her apartment. I think we ended up losing, but they offered us very little money, like 50,000 or 40,000. She didn't want to take it. So what could I have done? I mean, I don't know, but I wasn't as experienced back then. This is like 1999. I'm sure I could have done better, or maybe partnered with a more experienced lawyer. But we fought the good fight. But that's one that comes to mind. I'd have to think about that if there was any others that I outright lost that I could have maybe done something better. But yeah, that's a good topic. I'm going to think about that. Yeah. And Ben also says, what does my attorney also need to file a motion for summary judgment? Well, it depends on the facts of your case. If it's a rear end, you just get affidavits, you get a police report, photos, whatever evidence you have. I don't know what type of case you have. You know what I mean? Like, a motion for summary judgment is basically saying that prima facie, which means as a matter of law, there's not a question for a jury to decide. Because remember, a jury decides the facts, right? The jury decides issues of credibility, like who's telling the truth, factual questions. The judge just makes sure the law is being followed. So the judge is kind of like the umpire, right, in a baseball game. And the jury is kind of like saying, well, we believe you, but we don't believe you, because, one person might say, I had the green light, but the other person might say, no, I had the green light. Well, somebody's lying. So then the jury decides those facts. So if there's no issue of fact, right, and it's all as a matter of law, so super clear that either the case should be dismissed, or on the flip side, that the plaintiff should win and the defendant was negligent as a matter of law. And you can't even say, like, rational minds can't even say the defendant was not negligent, right? If either of those situations are true, either the plaintiff could win summary judgment or the defendant could win summary judgment. But what your lawyer needs to file it, I mean, your lawyer should know that. If your lawyer doesn't know that, well, then you don't have a very good lawyer. It's like saying, what does my doctor need to do surgery? Well, a scalpel, his knowledge of how to do surgery. Like, I can't tell you, your surgeon, like, where should he cut? He's going to do brain surgery. Where should he cut? I mean, it's kind of, I don't think you want me to tell you that. But yeah, if you want to text me, just text me about your case. Give me the facts. We could chat. I'm happy to discuss it with you. 347-566-9595. They opened up like a rice yogurt place, so it's not bad. You gotta have a little bit. I got the one with less sugar. Let me see. What other questions do we have here? Sorry, it's like scrolling down too much. So we did Ben's question. Callie says, how long can litigation actually take in a he say, she say case where no one wants to take fault? How does something like that get resolved? Well, it just gets resolved based on, whoever the jury believes. Either you settle it at 50-50 or whatever, or, it's never he said, she said only, right? Sometimes there's dash cam footage, there's videos, sometimes there's experts could look at the property damage to the car and say the crumple zones or this damage is consistent with X. And, there's a lot of other things you can do. Police officers, but you just, otherwise it just goes to trial and it's up to the jury to decide. And then Miss B says, thank you so much for all that you do. Symptoms and severity, CRPS, frozen shoulder, cervical radiculopathy, lumbar radiculopathy, cervical stenosis, constant swelling, and severe pain. Oh, no, I'm sorry to hear that. That's pretty serious. Haven't worked in a year because of the pain. Yeah. Okay. So I'm going to do that. I'm going to take a look at that and do that for you and maybe do a video about that, or maybe on the next live. I don't know if I can get to it today because I might have to run pretty soon, but maybe on the next live, I'll try to do it live but maybe it's better to do a video about it. I could start, I could do another video on CRPS because a lot of people, might have or might be curious about CRPS. It's kind of becoming more common. Like, I had a trial of CRPS, a very mild one, where we won $535,000. I did videos about that. And I think I've done other videos on CRPS where some lawyers have even won, 8 million, 12 million, much bigger results. So it's a very serious condition. And so what I could do is I could do a verdict search on CRPS, like in, I think you said Dallas, right? start with that, and then we could look at maybe CRPS nationwide, or we could look at CRPS in New York or a few other cities. I don't know how many cases there are just in Dallas, but I'm sure we could do Dallas, we could do Houston, we could do Los Angeles, Miami, a few big cities, or we could do the whole country and take a look. And Rumors Gossip says, can I call in? Yeah, I mean, you could just text me 347-566-9595. And then what I do is sometimes, if people like, what I could do is when we do the consultation call, I could have that recorded if you agree, but then I have it edited. So of course you're not going to have your name in there or anything confidential. It'll just be like the general questions. Like, for example, if you ask me about what this is worth, or you ask me about pre-existing conditions, just general questions that could be helpful for others as well, then we can do a video about that, right? And that could be a consult video. And I've done a few others. You could look in the I think you could look in the channel, and I've done a few consultation videos. So any of those could be like a sample so it'll probably be a video of me, because I'll just be calling you, but your voice would be in the background if you agree. And then, like I said, everything confidential would be edited out. And then let me see. Real Eyes asks, Arkady, you referred me to my lawyer. Thank you. Recently had an IME due to undiagnosed TBI. Oh, that's good. I'm happy that people are getting good results. If I'm referring you to a lawyer and you're happy with the lawyer, I'm happy about that. That's my goal, right? My goal is helping serious injury victims and families. I want to be able to help, whether it's just through a consult or maybe finding a lawyer for you if you need a lawyer. So absolutely. And Ben says, can a motion for summary judgment happen before the note of issue? Yeah, it can. So you can file a motion for summary judgment, look, if I got rear-ended, right? If somebody, not me, somebody got my client, whatever, client X got rear-ended, I could file a lawsuit today, and tomorrow I could file a motion for summary judgment, because I'm going to say, look, why do I have to do depositions of my client on liability? Why do I have to depose the defendant? Look at the police report. The defendant rear-ended my client. My client stopped at a red light. My client didn't do anything wrong. Here's a photo of the vehicle, damage to the rear of my car, damage to the front of that car. Here's an affidavit from my client on January 1st, 2025. I was driving. I stopped at a red light. I was stopped for a minute. And then all of a sudden, before the light changed green, it was still red. I got rear-ended at high speed. The guy didn't even hit his brakes. It's clear. And the defendant now the burden shifts to the defendant to explain a non-negligent reason why you rear-ended this car. So you could say, I was driving and he stopped short, but that's not really enough, right? That's not a non-negligent. So it's a really heavy burden. Then he has to, there's a lot of case law precedents, other precedents from the past, precedential case law. So basically it's really hard to overcome that, right? So if you can't come up with a non-negligent explanation for why you rear-ended that car, you lose, and then you're going to get summary judgment. So that's how it works. So yeah, you could do it before the note of issue. You could do it right day one. Okay. And Rumors Gossip says, I just won summary judgment as the plaintiff. What's next? So yeah, so if you won summary judgment, liability is decided. So now they're going to want to either do a trial on damages or settle with you as to your damages. And in New York, you can get 9% interest on the eventual judgment. And Crystal says, Miss B, I have CRPS as well, going on 3 years, and it's a very serious injury. I'm here for you. Yeah, no, it's really terrible. Yeah, CRPS is really, really bad. And Frost says, what, sorry, it keeps jumping too much. Oh, what if it's $1 million policy in trucking, Alabama case, and you want the full $1 million and the insurance company offers a high 6-figure and the lawyer negotiates but doesn't get the $1 million? Can the client just want to file the lawsuit for more money? Yeah, I mean, of course, you can just tell the lawyer you only want the $1 million. You want to go to trial. So, you have an offer. The offer is something, it's substantial, but it's just not enough, and you want more. And Rumors says, post the number. Yeah, I think I did. I posted it in the chat. Let me post it again. 347-566-9595. And then Veppy says, hello, Mr. Arkady. I had an undiagnosed head injury as a teenager. Then I suffered another TBI about 6 months ago, and I'm under a doctor's care. I had a brain MRI and I'm scheduled to see a neurologist. How can the doctor figure out how much damage I had done before I had this recent TBI? Right. So that's really up to the doctor, but there is a lot of research out there. And if you look at the journals, like the American Traumatic Brain Injury journals and other literature, they tend to say that if you have a second concussion or a second blow to the head, it's much worse. So it makes your chances for recovery much worse. It makes the severity much greater. So it's more severe. It's more serious, right? So the TBI now could be more serious. So that's actually, bad in terms of just generally. I'm not saying you, because I don't know, but generally it's bad for your brain health. But I guess that would be, in a way, that would give you more damages for the case, even though you probably don't want that. But so yeah, but the doctors, you could let the doctors figure that out. If you have strong like neurologists, neuroradiologists, neuropsychologists, they all work together as a team to figure that out. What's been there before, what was caused by the crash, and so yeah, that's usually how that's done. And Frost says the clients have the right to want the full policy limit and nothing else. It's the lawyer's job to fight for full justice and fight for the client's rights. Yeah, exactly. Now, you might not have the right lawyer for the job, right? Some lawyers might say, I don't want to go to trial. I'm afraid, or whatever. I believe that you already have like six figures. You have whatever, 200,000. That's enough. You should take that. If you go to trial, you could lose, which, depending on who's doing the trial and depending on the case, it's possible, right? So they might not want to risk it. So it really depends. Like if you have like say 850 and you wanted the million, but you're like, no, I only want the million, but they're not giving you the million. Then they say, okay, well, we're going to go to trial, but the trial might cost you 100,000. Well, now the lawyer might be, saying, well, wait a minute. So I'm going to spend 100,000 to try to get a million, but I already have 850. But what if I get zero? What if the jury gives me 350? Then doesn't make any sense, right? So financially, so you have to think about it. But if you're far apart, right? If you want a million and there are only like 100,000, well, then sometimes you have to go to trial. So it just depends on the circumstances. And Ben says, I already had 3 depositions as well as a 50H. I have a spinal fusion 2 months ago, and now they want the 4th. Is that normal? Well, it's not really a question of, I don't know why they would agree to do 3 depositions. Usually you just do 1 deposition. The best way to do it is to have all your medical treatment concluded and then be deposed after. But if you haven't had a deposition for this spinal fusion, then it is normal to the extent that, like I said earlier, I think in this video, in this live, they are entitled to a deposition, for the surgery. So if they haven't deposed you about the surgery, they'll just depose you as to the surgery. It might be short. It might be like an hour or half an hour, but they are entitled to that if they demand it. And then Rumors says, Arkady, what does the 9% mean after winning summary judgment? I just won my summary judgment. It took 2 years. The policy is 500,000. Umbrella is 5.5 million. So in New York, if you win summary judgment, like say in a car crash case, you can get 9% interest on any eventual damages. So that means that, like say, for example, a truck hits a car in the rear, right? So the car, then the driver of the car, the plaintiff, files a motion for summary judgment. The motion is granted. Now you have a judgment that the truck is 100% at fault. Then later, like 2 years later, you end up going to trial and the jury says, okay, the damages are $1 million. Well, now you get $1 million plus 9% interest going back to the date that the order was signed, giving you summary judgment. So if that was 2 years ago, you get 9% each year on the $1 million. So that's what, like about 90,000. So you get an extra 180,000, right? So it's almost 200,000 more above the million. So that's how that works. And then Shori Skies says, how much do you see a plaintiff in Philadelphia getting from Progressive? Platinum as their insurer after the at-fault party tendered policy limits from a diagonal T-bone collision. So you're saying you're the Progressive client, and then the at-fault person already tendered, and you're trying to go like against your own? Like, for example, if you have, let's say, 100,000, but the defendant who hit you has 25 and they've already tendered, then you get the difference from your own, like 75 more. How much they're going to pay you, Progressive? It just depends on your injuries. If your injuries are really, really severe and you have a big policy, like $1 million policy, and the other guy who was at fault only has, let's say, 25, you can get like 975 more. If you have 100 and the other guy has 25, you can get 75 more, right? And also your injuries. So just the fact that you could get 975 more doesn't mean that they're just going to pay you 975, right? If you don't have the injuries to warrant it, if you have like, a bulging disc with an epidural injection or a percutaneous discectomy, they might offer you like 100 more or 75 more. So it just depends on, you know what I mean? It just depends on like anything else, like the case. And Miguel says, why the Bronx is the best place for a case? I mean, it's not necessarily the best place. I mean, it has its pluses and minuses. The Bronx is very slow. So like the case I just did in the Bronx, the TBI case, we got 3.1 million when we started picking a jury, but the case was old. It took like 8 years to get there because it spent like 4 or 5 years on the trial calendar. Plus we had to take it off the calendar because the client had to go back for some more TBI treatment. So yeah, there were some issues. So it just takes a long time. So that's kind of a negative. Other places are much quicker, like Brooklyn, like Manhattan, but it's just basically the jurors. The jurors are pretty good in the Bronx. They tend to give money. They tend to agree with, plaintiffs and give money. As opposed to, let's say, Westchester, which is right next to the Bronx, right? But there people are more conservative. People might give some money, but much less. So in the Bronx, let's say you have the same injury, right? Like a claimed TBI or fusion. In one place, like in the Bronx, the fusion might be 2 million, 3 million or more. In Westchester, somebody might say, fusion, I'll just give you your medical bills. That's like, whatever, 50,000 or, you know what I mean? And they want to actually give you money for the fusion, what it's actually worth. So it just depends. Those are all generalities, right? Kind of like, yeah, just generalities. Like, this tends to be better, that tends to be worse, but it's not really, you could get a better verdict somewhere else, right? It's just, it really depends on the jury you pick. A jury is just a group of people, right? So it depends on the jury you pick and the evidence you present, and so it's always very fact specific, right? You might pick the wrong jury in the Bronx and have a really defense oriented juror in the Bronx who's going to give you 0 too, right? It's just, so these are all just generalities, just like almost like stereotypes. And then Rumors says, how old are, thank you. I'm not sure what the question is. How old is what? How old is, I'm not sure what that is. Money Dog says, question, if I have a severe TBI and it's not showing on an MRI, is there any other testing available to show the TBI to use in the courtroom? Oh yeah, of course. There's a lot. I mean, MRIs will only show a lesion if it's more than 1 millimeter, which is like the size of the tip of a ballpoint pen. So basically like this big, but the brain has, 85 billion neurons. So it's microscopic. So there's a lot of injuries that could be on a microscopic level that you just cannot see, or an MRI cannot see, because an MRI is only like 1.5 or even 3 Teslas just won't see it. Maybe a 7 Tesla would see it, but there's not really, that's more like academic, right? I think there's only like 1 7 Tesla or 2 in the whole country. So you're not going to get access to that, and it's really expensive. So then you have to use other techniques like neuroquant. With neuroquant, what they're doing is they're comparing certain regions of the brain to other people that are your age, your gender, your education level, and they're comparing you to those other people, and they're saying where you fall. So if you fall like in the 50th percentile, well, that's still within normal. But wait a minute, if in a certain area like the corpus callosum, you're at 1%, and then somewhere else, right, in an adjacent level, you're 1, and then you're 2, and then you're 1, and then you're 2. Wait a minute, you're only 1%, and everyone else is 99% better than you, then that could be suspicion, right? That could be one of the reasons why the neurologist could say, well, this is a traumatic brain injury, right? So that's one. Another one could be a DTI, diffusion tensor imaging, where it's almost like they look at the tracks of like the axons talking to each other through the the neurons talking to each other through the axons. So it's almost like the tracks, like train tracks, and then it'll actually visually show, oh, wait a minute, these tracks have breaks in them. So it's almost like they show you color imaging of like red and green and blue of all these tracts, fiber tracts in the brain, but all of a sudden you'll have breaks in them. That means that the brain is not communicating. So if I have a thought, right, like I want to eat an apple, so the thought has to come from one neuron to another neuron, all the way down to my hand to pick up the apple to take a bite. But as that thought is going, there's like breaks in the circuitry. There's breaks in the tracks. And that's what a diffusion tensor imaging. So those are two. I mean, there's others too. So it's really important to see a really good doctor to get that diagnosed. So yeah, we answered that question. OSRP, Mr. Arkady, I have a question. If a ceiling collapse happens and the landlord doesn't respond, the lawyer or judge, ceiling collapse. If the landlord doesn't respond to the lawsuit, from your experience, how much is epidurals and discectomy? Discectomy, I've done, over 500,000. We had one for 550. But if they don't respond, you have to get a default judgment and just keep pushing. And there are certain lawyers that actually know how to do collections and how to like enforce judgments in case they don't respond. But usually they do respond if they have insurance. And Frost says they know the ins and outs of insurance companies and the tactics to lower claims. I guess it's a win-win. Even though you said you never worked for insurance or corporations, you think those lawyers are good. Who? You mean the defense lawyers? I don't like using defense lawyers for plaintiffs, honestly, because defense lawyers just have a completely different mentality. They're not really like, plaintiff lawyers are like, some people will say, oh, another plaintiff's lawyer, he's just one of those like ambulance chasers, right? But there are some plaintiff lawyers that are ambulance chasing type guys, right? That put up the billboards and just want to make a buck at any expense and don't really care about their clients. But there are also certain lawyers that are like warriors for justice that just don't care, right? Even if they're offered money, they'll say no to $1 million. They'll say no to like 30 million, and they'll go to trial and they'll take a verdict because they're true believers and they're really passionate. Like, for example, there was a lawyer like Jerry Spence. He recently passed away, I think just a few days ago. He was like one of the founders, right, of the whole movement, like Trial Lawyers College, and he taught other lawyers. And then there's other lawyers that are like that. So those kind of lawyers, but it's pretty rare that one of those lawyers at one point worked for an insurance defense and then switched and is now passionate and doing an amazing job for the plaintiff. Now, there are some maybe that have, but a lot of the people that used to work for insurance defense just have that indoctrinated in their brain, right? It's kind of like learning a language. They learned that language, and then for them to like drop that and to switch and to become like a true passionate warrior for the injured, it's very hard. It's almost like two different languages, right? If you learned Chinese and now you have to learn like Swahili or something, it doesn't really work. So maybe there are people who maybe there are people who can. Like, I never worked for an insurance defense, and a lot of the lawyers that I know that have, they can switch and become plaintiffs lawyers, but they're not really like true believer type. They're not like the best trial lawyers. But some people can do both, and I would say that it is good experience. Just trial experience is good, whether it's criminal defense that you did or prosecution or insurance defense. Just being in the courtroom is always good. The more you're in the courtroom, the more knowledgeable you are. And then Shori says the injuries are PCS, dislocated neck discs, knee edema, injured shoulder, left hip, left myofascial pain, sleep apnea, and atrial fibrillation. Okay. That's the injury that you sustained. And what was the, oh, that's what he's asking about, that a progressive case? Yeah. I mean, depending on the policy limits, it sounds pretty serious. You could probably get a nice result. And then Real Eyes says, what specific TBI symptoms one will experience when left side of the head was hit? I'd have to research that a little more. That's kind of like, I mean, you'd know, right? Like it's not really, it's like, what symptoms are you experiencing, or what's, if it's not you, like whoever the person is, right? So you'd have to really see what symptoms you're experiencing, and then let the doctors then examine you and do like a full, like usually what I like to do is have a neurologist run like a battery of tests, and then refer you to a neuropsychologist, refer you to maybe a neuroradiologist to do like these neuroquants or DTI MRIs, or there are other tests as well, right? And then to then diagnose you. So yeah, I couldn't really say like what specific TBI, because it's never the same. One person could get hit on the left side of the head and have one group of symptoms, but someone else might get hit and have a completely different group of symptoms. I don't think there's the same symptoms that you always get from being hit in a certain part. And then Trevor says, an Uber crash a year ago caused injuries due to a driver's negligence and hit and run. The injuries required wrist surgery and now need injections for a bulging disc. Yes, that could be serious. Wrist surgery could be serious depending on the type. If it's arthroscopic, I've had cases with wrist surgery. We've gotten like 250, 350, and injections for a bulging disc could also be serious depending on the type of injections. Okay, I think that's pretty good. We're over an hour, so I think we did pretty good for a Friday. So thank you, everyone. Please like and subscribe to our channel. Let us know what questions you have. Let us know what videos you want to see in the future, and we'll do that for you. Have a great day. If you have a case, I wish you full justice. If you're injured, I wish you a full recovery and the very best of health. Okay, bye-bye, everyone. All the best.